Hey there, welcome back to yet another episode in the journey of demystifying the Patents Act. In the last episode, we discussed in detail various provisions of secrecy directions as provided by Section 35, 36, and 37. If you recall, the secrecy directions get enacted only when an applicant filed the patent application with the Indian Patent Office. What if an applicant files the application directly with the foreign patent offices, including PCT? In such cases, how is the controller going to keep a tab on the inventions which could be relevant for defense purpose or atomic energy? Tricky situation, isn't it? Patent Act has a provision to handle such situations as well. As per Section 39, no Indian resident is allowed or permitted to file a patent application with foreign patent offices, including PCT, without prior permission from Indian Patent Office. Before we go in detail about it, let's understand what is Indian resident. So Indian resident as such is not defined in the Patent Act, but we can take a definition or interpretation from how income tax interprets residency status of an individual. It says in a year, if your stay in India is more than 182 days, then you are considered as Indian resident. Similarly, if for the last 4 years, your stay in India is more than 365 days, then you are considered as Indian resident. So we can also take that definition to define whether the person was Indian resident or not. Coming back to this slide, let's focus on the PCT application. An international application, PCT application, can be either directly filed with IB or can be filed with one of the receiving offices. Now, India also is a receiving office. Even when you choose India as the receiving office while filing PCT application, you are not permitted to make such an application without taking prior permission from the Indian Patent Office. So what is the process of obtaining such a permission from the Indian Patent Office? As per Section 39, Rule 71, an applicant, an Indian resident, is required to make a request using Form 25. The details that goes in such a form are the applicant details, inventor details, and the reason for which you are obtaining such foreign filing license, along with details about the invention, for enabling the controller to review the invention in light of subject matter relevant to defense purpose or atomic energy. Once the controller has gone through the application and the invention is not relevant for defense purpose or atomic energy, the controller grants the foreign filing license. Usually this process needs to be completed within 21 days. However, there could be few delays as well. Now, in case of secrecy directions which were already invoked, in such cases, 21 days would start from the day controller receives the clarification from the central government. Upon receiving the FFL grant, your path to filing patent applications with foreign patent offices, including PCT, opens up like this. At this stage, you may wonder, is this the only way to file an application outside India, or do we have any other options as well? We definitely have other options. One of them being, you first file the patent application with Indian Patent Office as per Section 7 and wait for a period of 6 weeks before going ahead and filing application with any of the foreign patent offices of your choice, including PCT. If there is any issue with regards to our invention or the subject matter, controller is expected to get back to us with any directions, including secrecy directions, within 6 weeks. In absence of any such directions within 6 weeks, an applicant is free to file applications outside India. All this while we have been talking about Indian residents only, right? Any applications which has already been filed outside India and it were to come to India, such provisions will not be applicable to those applications. Now we have talked about all the folks who are complying with the requirements. We always have to talk about the people who are not complying. So as we discussed in the last episode, for such non-compliances, we have two sections, Section 40 and Section 118, for dealing with non-compliance. As per Section 40, an application will be deemed abandoned if contravention of Section 39 is found. Similarly, an applicant will be punishable with imprisonment for up to 2 years and or fine. So we learned a way of how Patent Office can keep a tab on inventions which pertains to defense purpose or atomic energy. This brings us to the end of this session. In the next video, we will discuss about a situation where a patentee has had enough of the obligations with regards to a patent and would want to give it away. So what are the provisions to do so? So I'll see you in the next video. Till then, be good and take care.